Rule 24C, Expedited Examination of Applications. The Patents Amendment Act 2016 introduced a new process of examination by which an applicant could get the examination of the application expedited. This is introduced in Rule 24C. In Rule 24B, we had the occasion to see how the examination process works, and we saw the various timelines that happens after a request for examination is made. And we also found that the reference made by the controller to the examiner is the only event which does not have a stipulated timeline. It is just mentioned in the rules, it shall be done as soon as possible, but there is no specified timeline as to how quickly this reference has to be made. Apart from that, every other process soon after the request for examination is made is drawn out by way of a timeline. Expedited examination is a special privilege that is allocated to two categories of applicants, which allows the applicant to fast track the examination of the application. Now let us see what those two categories are. Rule 24C1 states that an applicant may file a request for expedited examination in Form 18A. Form 18A was again introduced by the Patents Amendment Rules 2016 along with the fee as specified in first schedule only by electronic transmission duly authenticated within the period prescribed in Rule 24B on any of the following grounds, namely, now these are the two grounds on which you could make an expedited examination or a request for an expedited examination, namely A, that India has been indicated as the competent international searching authority or elected as the international preliminary examining authority in the corresponding international application, or the applicant is a startup. Startup is defined in the rules. Startup has special status in the first schedule. First schedule is the schedule which describes the fees. Startups are entitled to fees at the same level as individuals. So this is a privilege that is given to startups. Startups will be treated on the same fee structure as individuals, that is natural persons. So natural persons and startups are now together grouped as one category for the purposes of levying fees. So you can make a request for an expedited examination under Rule 24C using Form 18A, provided you have chosen India as the competent international searching authority or elected the international preliminary examining authority in India for the corresponding international application. Now, category A presumes that you have filed an international application. Category A is not open to an applicant who has not filed an international application. So, expedited examination, a request for expedited examination as per category A can only be filed by an applicant in India who has filed an international application and has chosen India as the international searching authority or the international preliminary examining authority. Now, India is international searching authority as well as an international preliminary examining authority. This was introduced by the Patent Amendment Rules 2013. Now, by this they created Indian International Searching Authority, that is Rule 19A introduced the International Searching Authority in India, and Rule 19F created the Indian International Preliminary Examining Authority. So, these two authorities were created by the Patent Amendment Rules 2013. So, the first category pertains to cases where an applicant has filed an international application and has chosen India as the international searching authority or the international preliminary examining authority. and these changes by were introduced into the patent rules by the amendment in Patents Amendment Rules 2013. The 2013 amendments made the Indian International Searching Authority and the Indian International Preliminary Examining Authority came into being by that amendment. So that's the first category. For you to make a request for an expedited examination, you need to file a international application. In the absence of filing an international application, category A will not be open to an applicant. So it's mandatory to, while seeking before filing form 18A, that you have first filed an international application and have chosen India as either the ISA, the International Searching Authority, or the IPEA, International Preliminary Examining Authority. Form 18A can only be filed by an entity other than a natural person or a startup, provided there is an international application in place. So the first category pertains to an applicant who has already made an international application in India and has chosen India as the ISA or the IPEA. The second category is quite simple. If the applicant is a startup, if the applicant is a startup as defined under the patent rules, then the applicant can make a request for an expedited examination. Now the rules give the definition of a startup in Rule 2FB. There is a new definition of startup under the Patents Amendment Rules 2017. Before the rules 2017 came into force, there was an existing definition of startup. So we will just see how the existing definition, which was there before the 2017 rules came into force, has now evolved into a new definition. Earlier, startup was defined through three criteria. The first one was the date of incorporation or registration. Now this had to be 5 years from the date of incorporation. So any entity which is 5 years from the date of incorporation or registration qualified as a startup. Secondly, it was defined in terms of its turnover. Now if the turnover in the said 5 years did not exceed 25 crores, again that was yet another criterion for deciding whether an entity is a startup. The third criteria was with regard to the working of the startup. If the working of the startup pertained to things like innovation, development, deployment, or commercialization of new products or services, processes included, and that should have been driven by technology or by intellectual property. Now, you will find that this third definition had a couple of things. One, it talked about the working, and the working had to be with regard to these things. It had to be with regard to innovation, development, deployment, or commercialization, and it had to pertain to these three things. Either it could be a product, a process, or a service, and it should have been driven by technology or by intellectual property itself. Now this has undergone a change, but bear in mind that this was how a startup was defined. These were the positive conditions for a startup. 5 years, it had to be new, it had to be registered within 5 years, you can claim a startup status, or the turnover was less than within 5 years, it did not exceed 25 crores. Again, it's a financial restraint. If you went beyond 25 crores, then you lose the status of a startup, and you had to be working in a particular field. Now, the earlier definition also said that you cannot create a startup by splitting or by reconstruction. So you have an existing business, you just can't turn around, split it, demerge it, and make a startup. It had to be a fresh start. And also, the fact that you are involved in the mere act of developing products and services which do not have a potential for commercialization, or undifferentiated products and services, or products or services or processes with no or limited incremental value for customers or workflow. Now, these are the negative conditions. If these conditions are there, then it may not qualify for a startup. And there were a couple of explanations. The first explanation said that the entity shall cease to be a startup if it exceeds 25 crores. Okay, so it crosses the threshold of 25 crores in 5 years, it ceases to be a startup. Then the entity had to be what an entity is. Entity had to be either a private limited company registered under the Companies Act, so it has to be an entity incorporated under the Companies Act, or a partnership under the Partnership Act, or a LLP, Limited Liability Partnership, under the Limited Liability Partnership Act 2002. Again, these are three enactments under which some form of registration can be done with regard to startups. So if you are not under the purview of these three acts, then you cannot be called an entity. So that gives the legal framework of who can qualify as a startup. Then turnover takes the meaning of the word, same word in the Companies Act, and you will find that again you had what the working of the startup should be. It should aim towards developing and commercializing new products and or significantly improve existing product or process and services, or create or add value now to customers or workflow. And finally, the explanation number 5 tells us that the reference rate of foreign currency shall prevail. Now, this is with regard to turnover of startups which has activity or income in foreign currency. So, the RBI guidelines shall prevail there. Now, this underwent a sea change in 2017. In 2017, we had this notification come up which amended the rules, the patent amendment rules. Now we have a much simpler definition. Now it just says a startup means an entity in India recognized as a startup by the competent authority under the Startup India initiative. So it makes room for quite a lot of startups to come in because there is no straight line definition. And if you look at the corresponding definition given under the startup initiative, you will find that that is something which can change over a period of time. There is no need to amend the rule anymore to incorporate the nitty-gritties of a startup or evolving startups. So all that you will find in the startup initiative. So this definition now refers back the definition of a startup to the startup initiative. And again, in the case of a foreign entity, the entity fulfilling the criteria for turnover and period of incorporation registration as per the startup initiative and submitting the declaration to that effect. Turnover again is calculated as per the RBI regulations. This is a notification that changed the patents amendment rules in 2017. Now, this essentially refers you back to another guideline. To understand the definition of startup, we need to go and see the definition of startup given by the DIPP. The Department of Industrial Policy and Promotion gives this definition by this notification which came out on 11th April 2018. You have a very elaborate definition here. The advantage of having a definition in a notification is that every time you notify, you come up with a new notification, there is no need to amend the patent rules. Here you will find that an entity, again they stick to the word entity, an entity shall be considered a startup if the time for it being considered a startup since incorporation is up to a period of 7 years. Now it used to be 5 years in the earlier definition, now it's up to a period of 7 years. And again the three acts remain: private limited company under the Companies Act, partnership firm under the Partnership Act, or LLP, Limited Liability Partnership, under the LLP Act. And it also adds a new sector. It says that in the case of startups in the biotechnology sector, the period shall be 10 years. So what this did was, now we have an extended period for being recognized as a startup. Now you have 7 years, which was not there. Earlier it was 5. And they created a new exception for the biotechnology sector where it is now 10 years. Now you find that you have two terms now. If you are in the biotechnology sector, then up to 10 years you will be considered as a startup. If you are in any other field other than biotech, then you could be considered as a startup up to 7 years. The turnover part of the definition remains the same, not exceed 25 crores within the 7-year period or the 10-year period. Then the working of the entity, which we also saw in the earlier definition, remains innovation, development, or improvement of products and services, though you would see that they have removed technology and intellectual property. If you compare with the definition to find that, we'll take a quick look to see how this has changed. You had seen here that there was a focus on technology and intellectual property that has now been removed. Or if it has a scalable business model, so one requirement is the startup needs to have a scalable business model with high potential of employment generation or wealth creation. Now, these are two new things which you didn't find in the earlier definition. So, what is required here is that the model has to be scalable and there should be potential for employment generation or wealth creation. And there is a proviso saying that, again, we found this in the earlier definition as well. Splitting up and reconstruction of existing businesses will not entitle you to get the startup status. Now, this is the definition. There is an explanation to the definition. The explanation tells us the point at which a startup shall cease to be a startup. Now, you will find that the 25 crore limit is still there. And again, in the case of a startup in the biotechnology sector, the entity shall cease to be a startup if the turnover exceeds 25 crores. But the difference here is that in the case of a normal startup, it's 7 years, and in the case of a biotech startup, it is 10 years. So the notification introduces two timelines for the status of a startup and the point at which startup shall cease to be a startup. Act is referred to as the Income Tax Act. There is a board which refers to the Interministerial Board of Certification, which means the Interministerial Board of Certification, and the members who comprise the board are listed here. Limited liability partnership is defined. Merchant banker is also defined. Partnership firm, there are other definitions. Recognition of startups. Now, there is a process for getting recognized as a startup that is also defined here. Then the tax provisions under the Income Tax Act is also mentioned in the notification. And finally, you have provisions on how a startup can be revoked or when it would cease to be a startup. So you will find more details about the startup definition in the website of Startup India. Now you will find that the same definition is given here. You can see that the 7-year period, the types of entities, turnover, and what they should be working towards when the startup shall cease to be a startup. And you will also find that there are some numbers around statistics around startups, the fact that how many startups have been recognized to date, funding and support, and there's quite a lot of details. You could also come up and find that the site gives you various information with regard to Startup India Hub, events and news, and state ranking action plan and other things. Subrule 1. Subrule 1 gives the two categories of applicants who can claim the status of a startup. The first one, the applicant should have preferred an international application, and the applicant should have chosen India as the ISA or the IPEA. The second category is that the applicant needs to be a startup. So we understand the first category. If in the first category the applicant is also a startup, then the applicant need not worry about taking an international application. Whereas the first category applies to a non-startup, that is an entity which could be a small entity or it could be a corporate entity. These are the three categories. You could either be a natural person or a startup, that's one category for the purpose of fees. You could be a small entity or you could be a corporate entity, which is the other category, which is a category other than a natural person, startup or a small entity. So, if you fall within that category, if you are not a startup, then if you need to expedite an examination of an application, you must file an international application. Otherwise, there is no way an entity which is not a startup can get its application expedited, the examination of the application expedited, unless there is a corresponding international application filed. So, if there is no international application, entities which are not startups will not be able to take the expedited examination route. Route is now explained. How does the Patent Office proceed when a request is filed? Sub-rule 2 states that a request for examination filed under Rule 24B may be converted to a request for expedited examination under Sub-rule 1 of 24C by paying the relevant fees and submitting requisite documents as required under Sub-rule 1. Now, if you had taken a request for examination under Rule 24B, which is a normal request for examination, which you would do using Form 18, you can convert that into a request for expedited examination by paying the relevant fees. The relevant fees are mentioned in the first schedule. Now, this allows you to convert a request that you have already made, a normal request for examination, into an expedited request. Now, obviously, if you are claiming the status of a startup, then you will have to file certain documents to claim that privilege. So, if you look at Form 18A is the form that is taken along with the request for expedited examination. In clause 2, you will find that there is this statement where the applicant makes the request for examination bearing dash for application for a patent number dash filed on these numbers have to be filled by the applicant may be converted to a request for expedited examination of the patent application under Rule 24C. So, by filing this form can also be used to convert an existing request. Now, this is mentioned in clause 2, and in clause 3 the applicant will have to show whether it is a startup or whether it has indicated India as the ISA or the IPEA. Now, this has to be filled. 24C sub-rule 2 tells the instances where you could convert an existing request for examination to a expedited request by paying the relevant fees, and that is done by Form 18A, because Form 18 is already filed in that case. Sub-rule 3 states that except where the application has already been published under subsection 2 of section 11A, or a request for publication under Rule 24A has already been filed, a request for expedited examination shall be accompanied by a request for publication under Rule 24A. This simply means when you file Form 18A, if you have not already filed Form 9, you have to file it along with Form 9. Form 9 is the request for publication. Now, the idea is, why would you make an expedited request for examination if your application itself is not published? Because if your application is not published, there is no way the Patent Office is going to examine your application. So, it becomes necessary for the applicant to take Form 9 if he has not already done it along with Form 18A. Sub-rule 3 says that when you are making a request under Form 18A, you have to accompany it with Form 9, which is a request for publication. It's quite obvious. The two cases where you will not do that is the application is already published, there is no need to then take Form 9, or the Form 9 is already filed. Those are the two obvious cases where you will not file a Form 9 with a Form 18. It's already done, it's already published, or the form is already filed. Sub-rule 4 states that where the request for expedited examination does not comply with the requirements of this rule, such a request shall be proceeded in accordance with the provisions contained in Rule 24B with an intimation to the applicant and shall be deemed to have been filed on the date on which the request for expedited examination was filed. Now, 24B, you will remember, is the request for a normal examination, or what we call a request for examination. If you file Form 18A and request an expedited examination, but the controller feels that you have not complied with the requirements of the rule. For instance, you are not a startup or you have not filed an international application, then it will be very hard for the controller to accord the status of an startup for your application. In such cases, the request shall proceed in accordance with Rule 24B. Rule 24B, we know, is the normal examination process, the examination of an application. Now, Rule 24B is normally initiated by filing Form 18, but in this case, because the applicant chose to file Form 18A instead of Form 18, but without satisfying the conditions laid out in 24C, the application will proceed as a normal application. So, though you have taken a request for expedited examination, if you do not comply with the requirements in the rule, then it will proceed as a normal request for examination under 24B. Understand that 24B is for the normal, we do not say normal, it is the request for examination, the ordinary one. 24C is the expedited request. If your Form 18A does not satisfy the requirements under the rule, then it will proceed as a normal examination. The date will remain the same, because the date of filing the Form 18A. Now, this could be regarded as a case of Form 18A being converted into Form 18. The date will remain the same as of the date of filing. Now, once the request is filed, and assume that the request is in order, the applicant is entitled for the status of a startup. The controller feels that the applicant is entitled to claim the status of a startup. Subrule 5 then states that the controller shall refer the request for expedited examination along with the application specification and other documents to the examiner. The process is same just as it was in 24B. In respect of the application where the request for expedited examination has been received, in the order of filing of such request, again this is the same, the controller shall refer it to the examiner. Provided that a request for expedited examination under this rule filed by a startup shall not be questioned merely on the ground that the startup ceased to be a startup after having filed the application for patent due to the lapse of more than 5 years from the date of its incorporation or registration, or turnover subsequently crossed the financial threshold limit as defined. Assume that a startup makes an application in its fourth year of its incorporation, and its financials are well within the limit, it has not exceeded 25 crores. So, let us say a startup after 4 years of incorporation makes an application, and let us also assume that the startup has a turnover of around 20 crores. Now, once the application proceeds, a request for expedited examination is filed. In the next 1 year, by the time the application is taken up for examination, the startup has already crossed the 5-year threshold. It is now in its 6th year, or the turnover has gone beyond 25 crores. Now, that technically would make the startup lose its status. But if a request for examination is filed while it was a startup, that request will proceed as though the startup still enjoys its status. It merely states that if a request for expedited examination is made, what is relevant is the point at which the request is made. If a startup is entitled to the status of a startup at the point in which the request is made, subsequent change in status by crossing the 5-year threshold or the 25 crore threshold will not affect the request that was made. It will still proceed as an expedited request. So, the request filed by a startup, so what the controller would investigate or would look at is the date on which the request was made. The date on which the request was made, if the startup fell within the definition of a startup, That is all that matters. Subsequently, as the application gets examined, if the startup loses its status, that should not be a ground for questioning the status of the startup. Subrule 6 states that once the reference is made to the examiner, the period within which the examiner shall make the report under subsection 2 of 12 shall ordinarily be 1 month but not exceeding 2 months from the date of reference of the application to him by the controller. We saw that in rule 24B it was 1 month not exceeding 3 months. So, in this case they have cut it down by another month. So, it is 1 month but not exceeding 2 months. So, the examiner has a maximum of 2 months to give the report, whereas in 24B he has 3 months. Subrule 7 states that the period within which the controller shall dispose of the report of the examiner shall be 1 month from the date of receipt of such report by the controller. This remains the same in 24B and 24C. Subrule 8 states that a first statement of objections along with any document, if required, shall be issued by the controller to the applicant or his authorized agent within 15 days from the date of disposal of the report of the examiner by the controller. Now, in 24B that was 1 month, that is now been reduced to 15 days. So, there is a difference here. The controller's report, that is the first statement of objections, which was earlier called the first examination report, shall be sent within 15 days from the date of disposal of the report of the examiner. In a normal examination, it is 1 month. Now, that has been cut down to 15 days. Subrule 9. Reply to the first statement of objections and subsequent reply, if any, in respect of an application where the request for expedited examination was filed, shall be processed in the order in which such reply for such application is received. This is similar to what we had seen in 24B. The process for the order in which the request shall be processed will be the order in which the office receives them. Subrule 10 states that the time for putting an application in order for grant under section 21 shall be 6 months from the date on which the first statement of objections is issued to the applicant. This is again, there is a similar provision that which says that it should be 6 months from the date on which the first statement of objections is issued to the applicant. This is the same in 24B. The 6-month period is the same. Subrule 11. The time for putting an application in order for grant under section 21 as prescribed in Subrule 10 may be further extended for a period of 3 months on the request for extension made in Form 4 along with the prescribed fee made to the controller before the expiry of the period specified under Subrule 10. So, before the 6-month period expires, you can make a request for extension of time by filing Form 4 and you will be granted a further period of 3 months. So, the 6 plus 3 formula that we saw in 24B also applies here. Subrule 12 is important. It is important for us to understand 24B itself because this throws light on a timeline which is not there in 24B. So, we will look at this and we will go back to 24B. Subrule 12 states that the controller shall dispose of the application within a period of 3 months from the date of receipt of last reply to the first statement of objection or within a period of 3 months from the last date to put the application in order for grant under section 21 of the Act, whichever is earlier, provided that this time limit shall not be applicable in the case of pre-grant opposition. Now, this statement is not there in 24B. Subrule 12 can be seen as the part which closes a loop. A loop, if it is an open-ended loop, then there is a possibility that you could say that time can be extended, but in an expedited examination, the controller shall dispose the application within a period of 3 months from the date of receipt of the last reply to the first statement of objection. Now, this statement is simply not there that there can be a last reply to the first statement of objection is not there in 24B, and there is no timeline in 24B which mandates the controller to dispose the application within 3 months. So, that is where the sub rule 12 becomes important for us in understanding the timeline in 24B. 24B, which is the case of a normal request for examination being filed, there is no mandate to dispose the application within 3 months from the receipt of the last reply. Whereas in an expedited examination, the controller has been given that mandate. Either it is 3 months from the date of receipt of the last reply, or within a period of 3 months from the last date to put the application in order for grant under section 21 of the Act. So within 3 months from the last date to put the application in order, the controller has to dispose the application. Again, this provision to completely dispose the application is not there in Rule 24B. It also factors the fact that if a pre-grant opposition is filed, then the controller cannot dispose the application till the pre-grant opposition is disposed of. So, this timeline will not apply, or you may not be able to get an expedited examination done if there is a pending pre-grant opposition. So, you could say that one way an expedited examination can be frustrated is when a pre-grant opposition is filed, because then the timeline need not be an expedited timeline, because the controller will be bound to dispose the pre-grant opposition before the application is disposed. Sub-rule 13 states that notwithstanding anything contained in this rule, the controller may limit the number of requests for expedited examination to be received during the year by way of notice to be published in the official journal. Now, the controller can make a statement in the official journal that in any given year they will be receiving only X number of expedited applications. So, anything that goes beyond that, the controller can say will be treated as an ordinary request for examination. Now, this is again to check the workload of the patent office. So, the patent office should not be burdened with a more stringent timeline, and as you saw in sub rule 12, the controller has to dispose the application within 3 months. So, if it is an expedited examination, to prevent the patent office from managing a workload which could happen if the number of expedited examinations are increased, there is a limit that the controller can put on the number of requests that could be made every year.